So I'm going to move on to think about knowing who is disabled, and this is a bit tricky, because there is one sense in which it's not technically up to us to know that someone is disabled. It's only up to us to know that something we know about the child suggests they might count as disabled under the Equality Act. The only way that you would know if that child counted as being disabled is if you found yourself at the tribunal with a claim of disability discrimination against you. And since we don't want to do that, we have to use all our skill, powers of observation and so on, to understand whether a child is actually disabled or not. Now, I think Christina has a quick poll for us. Leave that slide on the screen for a minute, Christina, and just have a look at that and consider nationally what percentage of children you think may count as disabled. And I'm talking about children up to the age of 16 here, because that's where we've got the best evidence at the moment. Okay, Christina, do you want to put your poll up?
Yeah, Charlotte's going to share it.
Thank you. Okay, would you be very kind of just click on that to let me know where you think, what percentage you think of children might count as disabled? I'll just give you a moment to think about that. Okay, has everyone managed to click on one of those numbers?
Maybe 30 seconds more.
Okay, thank you. I'm probably after a snap judgment here, really, rather than a very carefully considered calculation, just to have an idea. Let's have a look at that and see where we get to.
Yeah, end poll.
Can we see how that comes? Oh, interesting. Very, very, very interesting. So if you could just leave that up while we're while I'm just going through this. And I'll tell you where some of these percentages come from, because this isn't entirely straightforward, as you might imagine. So 3.7% at the top there is the percentage of children who have an EHC plan. 7% is the percentage of children who have for quite a long time been thought to count as disabled on the basis of the General Household Survey. I'm going to jump up to the 9% for a minute. More recently, in the around about 2014, 2015, the Government Equalities Office commissioned the Office of National Statistics to undertake a slightly more detailed survey where they were trying to get more closely towards the definition of disability in the Equality Act. And they came up with that figure of 9% of children under the age of 16. Up to and including the age of 16, I should say. Sorry, they came up with that 9%. Now, subsequently, the General Household Survey has found, against their own criteria, but again, trying to get a little bit closer to the definition of disability in the Equality Act, they've now identified 8% as the percentage of children counting as disabled. And that has become quite a significant figure now, because it's being quoted in the National Disability Strategy. It's quoted in a number of different places. So that has quite a significant amount of support for something about 8%. The 12.2% I've put in as a kind of a bit of a red herring, if you like, because that's actually the percentage of children identified at SEN support. And the 16% is the combination of children with special educational needs. So combining the 12.2% on SEN support and the 3.7% with an EHC plan. So that is roughly where those figures come from. I think it's quite hard to know how accurate the currently accepted 8% is. And, you know, it's also worth recognizing that that's it's going to be 2 or 3 children in each classroom in the country. So possibly more, depending on your class size, obviously. So I think it's important to recognize that most schools do not think of that number or that percentage of children as having a disability. Okay, thanks. Could we remove that poll? Thanks for taking part in that. It's interesting to see the sort of the estimates that you've thought might be right. So let's just look at this definition in a bit more detail then. So it says that a physical or mental impairment, a child has a disability if they have a physical or mental impairment which has an adverse effect on their ability to carry out normal day-to-day activities. So normal day-to-day activities for a young child in an early years setting would be running around, playing, climbing, sitting down, listening to stories, looking at pictures, looking at books, playing with equipment, etc., etc. In a secondary classroom, it would be sitting down for at a desk, able to take part in the learning, taking part in a range of activities, managing themselves and finding their way around the school, etc., etc. So the effect of this impairment must be both substantial and long-term. So let's have a look at the meaning of those terms. Substantial is defined as more than minor or trivial. Now, that's a very low threshold. So the way that I have to try and think of this is it is, as it were, big enough to have substance, which is not quite the way in which we think of substantial. Substantial, if it's a substantial meal, it's a big meal. But if it's just simply big enough to have substance, then it's more than minor or trivial, if you like. And that long-term criterion is a year or more. Now, that again is, you know, rules out broken legs. That doesn't count as a disability. It's likely to heal in less than a year. And there are a number of other considerations about this, but basically this is a much lower threshold than most people think of. And most people think of, you know, someone who's deaf or blind or has a physical impairment would count as having a disability, but less likely to think about these groups of children affected by an impairment, which might mean it's more difficult for them to manage their behaviour, to concentrate for longer periods of time, as you are often required to do in education. So there's a few other things to take into account here. All conditions need to be considered as they would be without treatment. So, for example, Hannah needs to be thought of as if she were not having those doses of insulin to manage her diabetes. That doesn't mean to say you have to remove the treatment to find out, but it needs to be taken into account. That is, this is the as if the condition were not managed by treatment. It includes progressive conditions, so conditions that we know deteriorate, have a greater impact as they progress. So cancer, multiple sclerosis, but actually those conditions are covered automatically because they are actually named in the legislation. And recurrent conditions are also covered. So for something like depression, for example, which may come in bouts, which may each one of itself may not last a full year, because it recurs, it may count as a diagnosis, as a disability. I'm just looking at the last word on that page, because actually these conditions, these considerations come into play regardless of diagnosis. And there is an interesting case that went to the upper tribunal because the lower tribunal found that the school had not discriminated because against a child, because at that time, that child had not received the diagnosis of the condition that they had. And the upper tribunal found that that did not matter. There is no link to diagnosis here. It is on the basis of a condition, named or unnamed, which has this impact on your ability to carry out normal day-to-day activities. Now, that's a little bit of a contradiction because, of course, if it comes to it, and that case is going to the tribunal, the first place they will look for an easy guide as to whether that child has a disability or not will be, they will look for a diagnosis. So there is a contradiction there in that you might look at that as a simple way of knowing whether the child might have a disability, but actually it is not a criterion against which you determine that they have. So here's my case of this mainstream pupil. So this was the pupil who the school saw, if you like, as a pupil who was disobeying school rules, who was naughty, if you like. He had a history of persistent low-level disruptive behavior. His concentration span in lessons was very significantly impaired. The school knew of his special educational needs. They knew that he had difficulty in concentration. They knew that he had difficulty in organizing himself. So he would often turn up in lessons without his planner or with the wrong equipment and so forth. They didn't see him as disabled, and that was the problem. They thought he was just a mainstream kid. So in other words, a pupil who was behaving badly rather than a pupil who needed to have those reasonable adjustments made for him. And what was interesting in this case is that the judge found, sorry, that the tribunal judge in that case found that the impact of repeated exclusions for that pupil who was in his GCSE year had a significant impact on the outcomes of his GCSEs, and indeed went further to say that if it had been the parent who had been allowing his son to be out of school for all that time, that amount of time, that he would have been taken to court for that amount of absence over the year. It amounted to very nearly half a term of absence in his GCSE year, which had that impact on the outcomes. So this was the pupil who found it difficult to get his uniform properly organized, his buttons not done up, his arriving at lessons with the wrong equipment, etc., and frequently being excluded because he'd acquired the number of sanctions that warranted an exclusion. So why do we need to know who may count as disabled? To understand the duties towards that pupil. And how would you know who may count as disabled? How would a school know? Well, there are a number of things, I guess. One, of course, teachers can observe a child and see where they're having difficulties, either in their learning or in their managing their behavior around their school. The school may have information about a special educational need, and that may in and of itself be an indicator, and schools should bear that in mind when they see a child who's having difficulty in complying. The child might be known to have a disability when they come to the school, but there's an important point here, because parents, if asked even, might not want to disclose a difficulty their child had. Now, why would that be? Well, because there's a lot of evidence that shows that parents of children with a disability or a special educational need may be encouraged by a school to go to a different school down the road, because they have a very good SEN department at that other school down the road, and a SENCO who really understands your child's particular condition. So a school may know that a child is disabled when they come to the school, but they may not if they're asking a parent, or they may not know how to ask a parent, and we'll come to that in a minute. So, of course, there are admissions forms as well, but a lot of the discrimination that happens around admissions happens before you get as far as the forms and the tightly controlled admissions process. And it happens in those informal visits before we decide which school we're going to apply to. Yes, and you may know through an exchange, a face-to-face exchange, parents or child themselves may volunteer information on a visit, but there is a challenge about asking the question, and it's very difficult to know how to ask the question, because if the information is not volunteered, we need to be aware that in the same way that the school may not understand the extent of the definition of disability, if we ask a parent, is your child disabled, they may quite likely say no, because they may have that, hearing impairment, visual impairment, physical impairment idea in their head, and they know that their child doesn't have a disability. So we need to think quite carefully, schools need to think quite carefully about how they ask that question. And the more openly that question is asked, the more likely they are to get honest information in reply. So if we ask a very open question, so, just tell me about your child, or, might we need to make any adjustments for your child? Is there anything that your child finds difficult at school? Might we need to make any adjustment? Is going to be more productive than other questions which are more closed. And we know that there are problems about how this question is asked. There's a wonderful woman, Christine Rose, who some time ago looked at admissions forms this is actually for further education. But, this is her report, and it's very neatly entitled to tell you exactly what's in this report. Do you have a disability, yes or no? Or is there a better way of asking? And it's subtitled Guidance on Disability Disclosure and Respecting Confidentiality. So now what she found was that actually, yes, this question was asked in a lot of the application forms to go to general FE colleges. And some of them were asked in quite insensitive ways. So here's an example of what she found. So, do you have a disability? Yes or no? Do you have a criminal conviction? Yes or no? Without any apparent recognition on the part of that particular college that, putting these two questions together might have an impact on how candidates might answer. So, we need then to think about how, instead of asking direct questions, we can perhaps have listening conversations, enabling parents and carers to talk more openly, giving them confidence that information they share with you will be used to support their child, rather than to try to bar them from entry, or to make admission to the school conditional in some way. And a lot of parents do tell us that they feel their child's attendance at school is conditional. So anything goes wrong, the school is on the phone immediately. Whereas for other children, it would be reviewed, the next review with parents, very often that child's presence in school is conditional on their exemplary behavior, and the slightest thing goes wrong and they're out, rather than the school trying to sort it out. It's immediate appeal to parents. So given that parents talk to each other and parents will be aware of this kind of problem, we need, schools need, in talking with parents about this stuff, they really need to give parents that confidence that the information they share with the school will be treated in confidence and will be shared as necessary. So here's the bit that parents know about. that, you know, it's happened to other parents or perhaps to them when they visited other schools. The Office of the Children's Commissioner found that there were, you know, a very significant group of parents of children with special educational needs who were encouraged to go to the school down the road. And that quote is a quote from one of the schools: "It might be best if you looked elsewhere." So they found a pattern which was linked to children with SEN and disabilities. So parents that have been told that themselves, or know of other parents who've been told that, are obviously going to be more cautious about sharing information. And quite a lot of schools tell us that, you know, this child arrived in the school and they were, you know, fine just for the first day, but by the end of the first week, the whole school was in turmoil because of this particular child. So why wouldn't the parent have shared information with the school about ways of helping their child to manage their behavior? Well, that is probably the very reason. Another listening conversation that needs to happen is with children and young people themselves, hearing directly from them what can help them to manage their behavior appropriately. A lovely example from one of the schools where we did some training was the head of English, who was finding constant interruptions from one student who had a shortened concentration span, yes, but he was always interrupting at the moment where she was trying to engage with another pupil. So she sat down with him and discussed with him how that might be managed better. And the conclusion they came to was agreed between them, almost, you know, it wasn't written down or anything, but it was almost like a contract between them, that so long as he managed not to interrupt when she was trying to speak to another pupil, she would give him her undivided attention at the end of the lesson, to make sure, check that he was okay with his homework, check on everything before he left the room. And that worked very well. Last I heard, it was still working, which was lovely. So asking, instead of, you know, as it were, have you got a problem? Have you got a disability or a special educational need? Asking instead, potentially, about any support needs or adjustments that you might need, or that your son might need, or daughter. Now, here we come to a bit which has become quite controversial recently, and a recent case which has resolved this, and I need just to take you through that. So there are particular conditions that are excluded from the definition of disability. And this is, as it were, to draw a line between what might be regarded as antisocial or criminal behavior and a behavior that arises in consequence of a disability. So excluded from the definition of disability is a tendency to set fires, a tendency to steal, a tendency to physical or sexual abuse of other people, exhibitionism, and voyeurism. So you can see the kinds of things that are excluded from that. But for some long time, where instances where disabled pupils have become involved in instances where they are deemed to have had a tendency to physical abuse of other people, those children have been excluded from the definition because of that being deemed to have a tendency to physical abuse of other people. So this is the case that eventually went to the first tier tribunal on the tendency to physical abuse. So this is the first level tribunal where the case is heard. So child L, only ever referred to by his initial, was excluded from school for physical violence arising from an incident in the school. He had autism, anxiety, pathological demand avoidance, and episodes of violence, which were as a result of these conditions. Now, his parents appealed to the first tier tribunal with a claim of disability discrimination, and the tribunal held that his behavior amounted to a tendency to physical abuse, and that therefore the school didn't have to justify the exclusion, as he was not disabled for the purposes of the Equality Act. Now, around about the same time, the House of Lords was raising a number of questions in a report they drew together. They were raising a number of questions about whether this tendency to physical violence was actually excusing schools from the duty to make reasonable adjustments. So if reasonable adjustments could have been made to help this pupil to manage their behaviour, then in effect, they would not be deemed to have a tendency towards physical abuse. They would instead be deemed to be disabled and have help from reasonable adjustments to help them to manage their behaviour and avoid those outbursts. So in effect, the exclusion was deemed not to be discrimination because the pupil was deemed to have a tendency to physical abuse. The case went back to the upper tribunal, and the ultimate resolution of that was that in education, a tendency to physical abuse does not remove a child from the definition of disability where they're exhibiting this tendency, or from the protection that the Equality Act provides. So in other words, it means that the school must make reasonable adjustments to prevent or manage challenging behaviour that arises in consequence of a disability, and cannot justify an exclusion in these circumstances as being proportionate. Now, remember that it's reasonable adjustments, and it doesn't mean that you would never exclude a disabled pupil, but where there could be reasonable adjustments made that would avoid that, then they must be made. And that's an important difference then between the adult legislation and the definition of disability in connection with children who are in education. So yes, so challenging behaviour, but challenging decisions for schools. And that is really knowing who counts as disabled. And how would you know that? Well, we've talked about the way that you might get information. We've got, we can make an analysis of the presenting behaviours. We can make reasonable adjustments. We have to anticipate those. Risk of that is that we might be seen as soft. If that pupil who'd sworn so colourfully at that teacher at the classroom door had not been excluded, then the school might have been seen to be accepting of such behaviour. So this needs to be managed very, very carefully and very astutely by schools, but making those adjustments and sharing an understanding of those, why some pupils might have rules applied differently. But the risk is of schemes of sanctions that are applied without that differentiation, and where the consistent application of sanctions is seen to be the very essence of fairness. Our sanctions need to be responsive and not just badged as being seen as good discipline, rather badged as ensuring all children are treated fairly by the variations that we make in our policies. Okay, another little pause there for a moment. Interesting to me, because you can see how those dilemmas arise for schools, particularly where you have a concept of fairness, which is about applying a policy in exactly the same way to all children.
I'll kick us off again then. I just want to go back to the statistics, Philippa, because the article that you sent round, I think you sent it to me, about the FFT Education Data Lab, reporting in their research that it's 44% of students will have SEN or disability in their school career. Like, how does that fit into the other statistics that we've got already? I know that's pretty recent data.
Yes. Now, the point in the FFT Data Lab article is about children who may have an SEN, a special education need, at some point in their school career, rather than at any one moment in time. And the other data is about, as it were, any one moment in time. So, I mean, some children may have a special educational need in primary school, but that may change when they move to secondary. Some students may not in primary, but may when they get to secondary. Because we've got a relative definition of special educational needs, the extent to which we identify children as having a special educational needs varies very, very significantly across schools. And there's some data in the past that shows it ranged between something like 10% of children in one school to something like 80% of children in another school, and a lot in between. Obviously, there's a sort of peak around 10, 15, up to about 20% as the total number there. But over a school career, more children will have a special educational need, will be identified as having a special educational need than they would be at any one moment in time. And there is more movement than we might think, perhaps. I know some more detailed analysis was undertaken when I was in the DFE as a professional advisor. We did some quite detailed work on local authority data and looking at examples from different local authorities about movement in and out of what we often call the SEN register. But that's the reason for that discrepancy there. But it's quite a big discrepancy, isn't it?
Philippa, can I ask, I know there's a difference between the way social care defines disability and education. And I just wonder where you think that's landing at the moment.
Yes, and I suspect there the definition there provides a higher threshold, but in practice, of course, the definition for social care is largely used in relation to the register, which local authorities are required to maintain, of children in need, and disabled children count as children in need under the Children Act. Now, that's a problem because the threshold for qualifying for something via being on the register is often very high, and so the threshold gets adjusted in relation to the extent and availability of, for example, short breaks. So there is quite a lot of adjustment of thresholds and massive variation in the percentage of children who get put onto the disability register across different local areas. But largely, children get put onto the register when they need a service, such as short breaks. So the threshold is often set in relation to the availability of services such as short breaks. But in general, I think probably, Diana, it is probably a higher threshold anyway, because the definition is slightly different. And just an interesting point on that, when the Children and Families Act went through Parliament, the references to disability were tied in to the Equality Act, which by then was in place. Obviously, before that was the Disability Discrimination Act. But so the Children and Families Act specifically references the Equality Act when it refers to disability. It says children who count as disabled under the Equality Act definition.